Good morning, students. This is Sreekanth, Assistant Professor, Dr. Ambedkar Global Law Institute, Tirupati. Right. So, I am signing in for company law. Entire company law, you have to know only three things: separate legal entity, memorandum of association, and articles of association. Now, you know that at the time of formation of a company, certain documents are to be filed with the registrar of companies. Yes, what are those two documents? Right. One is Memorandum of Association, other one is Articles of Association. So, these are the two basic documents which you have to file during the formation of a company. Now, the first important document to be filed with the Registrar of Companies is the Memorandum of Association, briefly called as Memorandum. As a matter of fact, the preparation of this document, it is the first step in the formation of a company. It contains the fundamental conditions on which the company is to be incorporated. In fact, this document is of great importance in relation to the affairs of the proposed company. It may rightly be called as a charter or constitution of the company. Why? It regulates the relationship of the company with the outside world. This memorandum of association lays down the powers and objects of the company and the scope of the operations of the company beyond which its actions cannot go. Remember, in India, constitution is supreme. You cannot violate the constitution. Likewise, every company, this memorandum of association is the constitution of the company. Company cannot violate memorandum of association. If the company violates memorandum of association, it is ultra vires. The scope of the operations of the company cannot go beyond the memorandum of association. Whatever that has been enshrined in the memorandum of association, company has to abide by the same. If the company's acts go beyond the provisions of the memorandum, its act will be ultra vires and struck down by the courts. That is, it have without any legal effect. In fact, in Ashbury Rail Carriage and Iron Company versus Rich, this observation has been made by Lord Keynes. The memorandum is, as it were, the area beyond which the actions of the company cannot go. Remember, once you file the memorandum of association with the registrar of companies, you cannot alter the memorandum of association unless and until it has to be passed by a special resolution by special majority of the shareholders. So memorandum of association, it is a public document and every person who deals with the company is presumed to have the sufficient knowledge of its contents. The main purpose of memorandum of association is to enable the shareholders, creditors, and all those persons who deal with the company to know what are its powers and what is the range of its activities. Now, the shareholders will come to know that for what purposes their investment is going to be utilized. They will also know the risk involved in the investment. The other persons dealing with the company shall also know whether the dealings are in relation to the matters within the objects of the company. So this is that much important. Remember, every company, let it be a public company, private company, statutory company, chartered company, foreign company, holding and subsidiary companies, one person company, associate company, every company has to invariably prepare Memorandum of Association and Articles of Association. It is the constitution of the company which company cannot go, it cannot bypass, it cannot override the Memorandum of Association. Remember, again, Memorandum of Association should be within the purview of limits of the Companies Act. If there is a conflict between Companies Act, Memorandum of Association and Articles of Association, Companies Act will prevail. So you know that the Memorandum of Association is the first basic document which every company has to prepare. It is the first document to be filed with the registrar of companies is Memorandum of Association, and it contains the fundamental conditions on which the company is to be incorporated. It may be rightly called as a charter or the constitution of the company, and it regulates the relationship of the company with the outside world. If the company's action goes beyond the Memorandum of Association, it is ultra vires. That means it does not have any legal effect. Right. Now let us see what are the clauses that has been contained in the Memorandum of Association. There are only six clauses in Memorandum of Association. Number one, name clause. Number two, registered office clause. Number three, objects clause. Number four, liability clause. Number five, capital clause. Number six, association or subscription clauses. How many classes are there? Six classes. Name class, registered office class, object class, liability clause, capital clause, association or subscription clause. Now let us go one by one. First one is name clause. Yes, this clause of Memorandum of Association, it contains the proposed company's name. So you know that company is a legal person, must have a name to establish its identity. As a matter of fact, the name is the symbol of personal existence of the company. A company may choose any suitable name it likes. Yes, company can select any names. However, there are certain rules to be followed while selecting your company's name. First one is name should not be undesirable. The name of the company should not be undesirable in the opinion of the central government. If it is undesirable in the opinion of the central government, the company cannot be registered with such a name. Central government will reject your name. Here you have to prepare six names and send it to Registrar of Companies for approval. Then central government means who? Registrar of Companies only. He will say you cannot put Gandhiji in your company's name as your company's name. Nehru as your company's name. Bharat, India, you cannot put. Only government is empowered to put its name in its company. So the name should not be undesirable in the opinion of the central government. So second one is the name should not be identical with another company's name. Suppose if I want to start a company, I cannot put my company as Reliance. Why? There is already one company in existence. The name of the company should not be identical with the name of an already existing company. Not only identical, even it should also not too closely resemble the name of another existing company. The purpose of prohibiting the use of such names is that company must not create an impression that it is carrying on the business of another well established company. If such a name may be declared undesirable by the central government, if the company gets registered with such a name, the other company with whom the name resembles can apply to the court for an order that the new company be restrained from having an identical name. If one company puts its name which is identical to another company, that another company may file a petition in the court suit to get injunction, to get restrained order. In fact, the name of the company is a part of its business reputation. If a new company is allowed to have an identical name, the reputation of the existing company is definitely injured. Therefore, the courts grant injunctions prohibiting the use of identical name. So, first rule is the name should not be undesirable. Second one is the name should not be identical with another company's name. Now, third rule is the name should not be a prohibited one. Here we have one act, Emblems and Names Prevention of Improper Use Act 1950. So, this Emblems and Names Prevention of Improper Use Act 1950 specifically tells these names you cannot keep to your company. So, this act prohibits the use of the name and emblems of UNO. You cannot use name and emblems. My company name is UNO. It is not permitted. WHO, World Health Organization, it is not permitted. Indian national flag, you cannot use. Remember, official seal and emblem of central and state government, you cannot do. The name and pictorial representation of Mahatma Gandhi, Prime Minister of India. So, if you do this, it is an offense under Emblems and Names Prevention of Improper Use Act 1950. Fourth one is the name should end with the words limited or private limited. The public company with limited liability must add the word limited at the end of its name, and the private company the word private limited. If the purpose of adding these words is that all persons dealing with the company should have a clear notice that liability of the members is limited. If it is a public company, it must end with the words limited, and if it is a private company, it should end with the word private limited. So the name should end with the words limited or private limited. So then this name of the company must be painted on the outside of every place where the business of the company is carried on. You have to paint. You may have hundreds of offices. On outside of your every office, the name of the company should be painted. The name of the company together with the address of registered office should be engraved on its seal, and name of the company together with the address of registered office shall also be mentioned in the business letters, negotiable instruments, orders, receipts, notices, and all other official publication. So, you know that how a name should be. It should not be identical, it should not be undesirable, it should not be a prohibited one, it should end with the words limited or private limited. So, now you have chosen the name class. Next, moving on to next class is registered office class. So here in this class, you have to mention your registered office address. This class of Memorandum of Association contains name of the state in which the registered office of the company is to be situated. The registered office of the company must be in existence from the day when the company starts its business or from 30th day of the incorporation of the company, whichever is earlier. The day you start your business or from the 30th day of incorporation of the company, whichever is earlier, you have to provide the registered office. Exact situation of the registered office must be decided immediately on the commencement of the business of the company or within 30 days of its incorporation. You know why you have to provide this registered office clause is all the important documents and books of the company such as annual returns, minute books, register of members, etc. are kept in the registered office. You have to keep this in the same this office. All important communications, notices, circulars, process of the court, and other correspondence relating to the company are also addressed to its registered office, and it is very important to determine jurisdiction of the courts in which the legal actions ought to be brought by or against the company. So registered office, here you have to keep all important documents and books like annual returns, minute books, register of members, whatever, everything you have to keep in the registered office, and especially for service of summons notices of the courts to determine the jurisdiction of the courts. It is very important to have a registered office clause. The registered office and head office are not one and the same, remember. You can have head office at one place, but you have to provide one office address, that is known as registered office address. It is registered office clause, right? Now moving on to third class, it is objects clause. It's very important clause. This clause of Memorandum of Association contains the objects for which the proposed company is to be formed. For what purpose you have formed the company, you have to mention in the object clause. It is the most important clause of the memorandum, and it should be drafted very carefully. The objects of the company must be stated in a clear and definite terms. Right? Now, the object class has to be divided into two subclasses, namely main object class, other object class. So, object class, main object class, other object class. Main object class means this clause will state the main objects of the company which are to be pursued on the incorporation of the company, right? Now, other object clause means this clause will state those objects of the company which have not been mentioned in the main object clause. Now, the object should not be illegal or against the public policy. The object should not be against the provision of the Companies Act. The object should not be against the general law of the land. So, the company must be formed for lawful objects which should not be against the provisions of the Companies Act or any other Indian law for the time being in force in their country. Now, it's very important. Once you determine the object class, you cannot amend the same. Now coming to fourth class, it's liability class. Now let us go into this class. This class of Memorandum of Association contains the nature of liability of the members of the company. This class is necessary for those companies in which the liability of the members is limited. The memorandum of such companies must state that liability of the members is limited. You know, company may be limited by shares or limited by guarantee. In the case of companies limited by shares, the liability clause must state that liability of the member shall be limited by shares. That means if the company issue one share, the share value is 10 rupees. Now if you want to purchase one share, your liability is only 10 rupees only. If the company asks you to pay more than 10 rupees, what you will tell? I am going to purchase only one share. That share value is rupees 10. I don't pay more than 10 rupees. That means your liability is limited to the nominal value of the shares held by you. This is in the case of companies limited by shares. Now, in the case of companies limited by guarantee, You are signing the application. What company says, I am going to issue one share. Each share is rupees 10 rupees. So your liability is rupees 10. Apart from 10 rupees, you have to pay another 2 rupees if the company goes into winding up or liquidation. That means you are accepting 10 rupees plus 2 rupees addition. You are giving the guarantee. Now, this liability class will state the amount which every member undertakes or to contribute the assets of the company in the event of its winding up. So you are giving the guarantee, not only the share amount, I will give some additional amount as the guarantee. So this is known as liability clause. Liability is limited by share, liability is limited by guarantee. Right, students? Next, moving on to capital clause. Yes, capital. Every company needs some capital. No, they have to start the company with some capital. So this clause of Memorandum of Association contains the amount of share capital with which the company is to be registered. This clause should also state the number and value of the shares into which the capital of the company is divided. We are having different types of share capital. We are going to learn when that chapter comes. The capital with which the company is registered is called registered capital, otherwise known as nominal capital, otherwise known as authorized capital. So, the company cannot issue more shares that has been authorized by its memorandum of association. You cannot issue more shares. So, once it is mentioned in the memorandum of association, that is the limit with which you can issue the shares. So different types of share capital. So here it is registered share cap, registered with whom? Registered with register of companies. It is also known as nominal capital or authorized capital. Authorized by what? Authorized by memorandum of association. For example, the capital of the company is rupees 50 lakhs divided into 5 lakh equity shares of rupees 10 each. So this is the capital of the company with which you can form the company. So capital clause. How much capital you are going to pump into the company. Next one is association or subscription clause. This clause of memorandum of association contains the names of the persons who sign the memorandum and state that they are willing to form themselves into a company. You know, public company 7 persons. Yes, private company minimum 2 persons. These persons are called subscribers. They have to sign the memorandum of association. Now, this declaration must be signed by each subscriber. Minimum how? Minimum how many? 7 in case of public, 2 in case of private. In the presence of at least one witness who must attest the signature. Moreover, every subscriber must write his name, address, description, and occupation if any, and the number of shares which he takes. Now, every subscriber must take at least one share. In a case of public company, the memorandum must be signed by at least 7 subscribers, and in the case of a private company, by at least 2 subscribers. After the memorandum is actually registered, no subscriber can withdraw his name on any ground whatsoever. In fact, the Memorandum of Association concludes with the subscription clause. This being the concluding clause, it need not be numbered. So these are the 6 important clauses in the Memorandum of Association. Right. Let us see what are those once again. Yes, name class, registered office class, object class, liability class, capital class, and association or subscription class. Students, this memorandum of association is very, very important from your examination point of view. You can definitely expect a question from this Memorandum of Association. Yes, students got something today. Yes, we will see tomorrow. There is another important concept known as doctrine of constructive notice and indoor management. We will see those doctrines. Got something today? Yes, this is Sreekanth signing off today. Have a good day, students.